imprisonment of citizens for free speech, even if it is reckless. The African Court of Human and People's Rights, in a landmark judgment in December 2014, overruled the conviction of a Burkinabe journalist, Issa Konate, and ordered Burkina Faso, and by extension other African countries, to amend laws to make it compliant with international standards and treaties by repealing custodial sentences, among others, for free speech. Now, wouldn't you say it is fair to question the court's application of contempt that in recent times have led to custodial sentences for 5 of our citizens for free speech, even as we have this Issa Konate case where custodial sentence is not promoted?
Thank you. It's important. I will not go as far as you want to take me with your question, but I will, with all due respect, Honorable Chair, because I'm not going to justify or not. I'm not going to discuss the sentence in that particular case. But taking the Issa Konate case, firstly, the Issa Konate case did not have anything to do with contempt. It was based on a particular kind of French, or let's say civil law enactment, but it's apparently quite common in civil law countries to have a crime of insulting.
It was defamation.
They call it, yeah, but it was insult in the French version. It was more of insult rather than defamation. We had to really fight, as judges, we had to fight over what was the correct terminology, whether it was insult or it was defamation, because our concept of defamation might be somewhat different from theirs. But in any case, contempt is also something which is entirely different. And in the scandalizing of the court, and we come back to that. It was not defaming. They didn't defame anybody. They contemned the court. And that is a specific power which is recognized even under the Constitution.
With all respect, I'm satisfied with that.
Let him conclude, then you take it over. Or if you're satisfied with the answer.
Yes, I'm satisfied with the answer, and I want to just do a quick follow-up and see if we get better clarification. Yeah, I mean, so I just want to know if the argument or the position is that with contempt, once in the exercise of your freedom to speak, you contempt or you do something that is considered contemptuous to the court. Yes, contumacious. Thank you. To the court, it means you can suffer custodial sentence for that, and it doesn't matter. The international standards that says free expression should not lead to custodial sentence will not be considered.
Free expression, even in the international standard, does not mean contemning the court. It does not mean, for that matter, even damaging the reputation of other people. If, for example, in our separate opinion, we made that quite clear because we felt that some of the areas where they felt the person had defamed or insulted the people, we said there were other alternative crimes, like hate crime, and so on and so forth, that could have been applied. Hate crime in the international sphere is considered a legitimate crime in the sense that if you criminalize hate speech, there's nothing wrong with that because it lies in the area of sedition and so on and so forth. So we need to, there are fine lines, and I don't know, I don't think members want to listen to a lengthy debate on the point. Thank you.